Welcome everyone to ERISA Fiduciary Governance, Part 3 of 4, Selecting and Monitoring Service Providers. Thank you all for joining us. The Benefits Compliance team will be answering the questions you send through the Q&A today. We'll try our best to answer all of your questions, but if for whatever reason we're unable to get to your question today, please follow up with your advisor for further assistance. Today's presentation is being recorded. We'll be sharing the recording in the follow-up email and on the NFP website. If there are any portions of this call that you missed, by Monday, you'll receive an email with a link to the full recording. The PowerPoint slides used during this presentation will be shared in the same email. At this time, I'll hand it over to Chase Cannon, Senior Vice President and Deputy Chief Compliance Officer of Benefits Compliance at NFP, Carol Wood, Vice President and Counsel of Benefits Compliance at NFP, and Travis Walker, Regional Vice President of the West Region of Benefits Compliance at NFP. Chase, the floor is yours.
Amber, thank you so much for that intro. Thanks everybody for joining today. We're so excited that you're with us and that you've stuck with us. This is part 3 of our 4-part series on ERISA fiduciary governance. And we're just grateful that you're here. And we know it's a lot when it comes to figuring out what all of this ERISA fiduciary governance and fiduciary duties, what it means for you as a company sponsoring a group health plan. And we know it's also a process. This has been for educating and learning about this, it's a process, and also for understanding and implementing solutions that we're talking about and different parts of the process. It's all a process, and it's going to take time. So, but we're glad you're here. Carol and I have been kind of the primary presenters on this series for the first couple of webinars, and we've had different special guests. And today we have another special guest who's a member of our team, Travis Walker, but also has a unique perspective and background. I think everybody knows Chase and myself and Carol and our backgrounds as ERISA attorneys and with NFP. But Travis, coming over from the carrier side a little bit. Travis, you want to take a second to just give us your background really quickly so everybody can know your expertise?
Well, hi everyone. Hey, happy to be here and provide some insight during the conversation today. So, prior to joining NFP, I served as a compliance officer for a third-party administrator and also oversaw a compliance team for one of the major health insurers. That scope of work, which spanned nearly a decade, included compliance support for group fully insured and self-funded business. It also covered accepted benefits and individual insurance across multiple brands nationwide. Like Chase Carroll, I am an attorney by trade and happy to provide some general guidance as we go through the discussion today.
Yeah, it's awesome. So Travis has been with us for a little bit now, but we're so grateful for his background, and it will help illuminate some of the things we're talking about today. The focus today, again, is on part of the process, the fiduciary governance process, specifically selecting and monitoring service providers. So obviously very relevant with his background. And we're excited to get his perspective on what we're talking about today. Quick disclaimer that this isn't meant to serve as legal or tax counsel or advice for you. Seek out your own legal or tax advice for specific advice, and that our information is current as of today. So with that, we're going to get into our agenda. We're going to talk about delegating plan duties to a service provider. What does that mean? Defining the role to outsource, selecting a TPA, ASO provider, or carrier. What are the contracting considerations there? What's the monitoring of that specific provider look like? And we're going to talk a little bit about recent litigation because that's always playing a big part of this, right? We kind of started our series talking about how litigation has really thrust this idea of ERISA fiduciary governance into the limelight. And even though the ERISA fiduciary duties are not new, right, recent litigation is just really pushing this into the spotlight, and so is one reason we're talking about that. So it's helpful to understand what's happening in the courts. What are the cases? What are the plaintiffs in those cases looking, arguing, and that in turn helps inform us and you as plan sponsor on the things to focus on as you're setting up your and running your fiduciary governance program. We'll talk a lot about the resources we have to help support all of this as well. But Carol is going to come in here and get us started talking about delegating plan duties and who's responsible for selecting service providers. So Carol, you there? Good to take this part
Yes,
on?
yeah, thank you,
Uh,
Chase, and good afternoon, everybody. And this first few slides, just a bit of review here. We're talking about delegating duties to a service provider. Well, who's responsible for doing that delegating? It's generally the ERISA plan administrator, who's responsible for the plan's overall compliance and operations. It's really an extensive role they play, and they're the named fiduciary, and their responsibilities include prudently selecting plan service providers, which would include the medical plan carrier or TPA, and also maintaining the plan's claim procedures. And the plan administrator should be specified in the ERISA plan document, the plan sponsor employer. For a corporation, the board of directors would be the default plan administrator if no one is specified. Next slide. So how does the plan administrator delegate duties to a service provider? We know that the plan administrator can delegate those duties, including fiduciary duties, to a third-party service provider, but it has to be in accordance with the ERISA plan document. And when we talk about fiduciary duties, we're talking about those that involve the exercise of discretionary authority or control, either over the plan or the plan assets. And if fiduciary duties are delegated, the party accepting that delegation becomes a fiduciary accountable for the delegated task. So if we use the example we talked about more depth today of the self-insured plan administrator, contractually delegated fiduciary authority to review and decide plan claims and appeals, then that TPA is a fiduciary to the extent of that claim review authority. The plan administrator must act prudently in selecting the third party, and they also can contract away their own fiduciary status by the delegation. Rather, the plan administrator remains responsible for monitoring the third party and assessing whether they are properly performing the delegated duties. Okay, so we know we're going to outsource certain responsibilities. Invariably, any plan administrator does, but it's important to define that role that we're outsourcing. So what are a group health plan's obligations with respect to plan claims? And this is a role that almost, if not almost all or all plan administrators outsource to some degree. The employer as a plan administrator is responsible for maintaining reasonable claim procedures so participants can receive the promised benefits. Most employers would typically hire a carrier or a TPA to process claims, but should understand the general claim requirements in order to be able to prudently select a provider who can comply with those requirements. Of course, this is particularly important for fiduciaries of self-funded plans who may retain some fiduciary role with respect to claims adjudication. So employers should have a basic familiarity with the timeframes within which to decide claims, the contents of benefit denial notices, and also the standards for appeals of benefit denials. Additionally, and newer external review requirements and also certain requirements under the No Surprises Act. Okay, so what are the required timeframes for plans to decide claims? These vary, and they're outer limits within which plans can decide claims. So for an urgent claim, where the participant's health would be threatened, if the normal pre-service time frame applied, it's as soon as possible, not later than 72 hours. That's for both claims and appeals. That's a quick turnaround time, understandably. Then for pre-service claims, this is before medical care is received, such as a pre-authorization, reasonable time not to exceed 15 days for claims, 30 days for appeals, and most claims which are post-service, it's a reasonable time not to exceed 30 days for claims and 60 days for appeals, with certain extensions and specific timeframes when more information is needed from the claimant. Next slide. What must be included in the notice of a claim denial? And I won't read everything here, but if a plan denies a claim, obviously a notice needs to be sent to the claimant, the participant, and importantly, it should be written in a language that the average participant can understand. Specify the reasons for the denial. For example, it's not medically necessary, it's not covered by the plan. Reference the specific plan provisions upon which the denial is based. If applicable, any additional information that's needed from the participant so they can perfect the claim, they can appeal the claim. And then a description of how to initiate an appeal, and then rules and some other information relied upon in the decision. Now, the idea behind the claim denial notice is that there should be a meaningful dialogue. The claims administrator should be explaining to that participant, why their claim, was denied. So they can proceed to move forward, assuming that it's for a covered service. It may be additional information is needed. And the same for an appeal. There's some additional information, but it's very similar. And this is an area where, as we'll discuss later, we see a lot of litigation. In fact, there's an article in Compliance Corner that I wrote, I think it was published today, where there's a lot of frustration because participants aren't receiving the notices that meet the requirements. And after exhausting their process with the plan, then they go to court and sue the claims administrator. So it's really important to understand what's required in these notices. Next. And what are the standards for appeals of benefit denials? Basically, the claims procedure must provide for a full and fair review of a benefit claim, and the minimum standards for appeals require the appeal. One of the things is be reviewed by someone new. It can't be the same person who reviewed made the initial decision, or that person's subordinate. And the reviewer must give no deference to that initial decision. The reviewer must consult with a medical professional if the denials is based on a determination as to whether a particular treatment, drug, or other item is experimental or not medically necessary. Plans can require no more than 2 levels of review, and mandatory binding arbitration of claims is generally prohibited, but non-binding arbitration is permitted if done within certain timeframes. How did the ACA and No Surprises Act affect claim review requirements? Well, the ACA amended ERISA by enhancing internal claims and appeal requirements, and one of the main ways is by making external review procedures available. This is generally just for non-grandfathered group health plans, which is probably most plans, and it's designed to make sure that claimants denied coverage, have a judgment from an independent reviewer, not someone employed or contracted by the health plan, evaluate that denial. So self-funded plans generally have to comply with DOL external review procedures, and the process typically is arranged through the TPA or ASO provider. Fully insured plans generally must comply with their state's external review process, and the carrier is typically responsible for arranging that external review process. In the No Surprises Act, we know the No Surprises Act covers surprise billing claims, and they're eligible for external review, and this would extend then to grandfathered plans as well. Next slide. All right, so in most cases, or in many cases, the plan administrator, particularly for a fully insured plan, is going to delegate the entire responsibility of the claims review and appeal process to the carrier. With self-insured plans, in some cases, the self-insured plan sponsor may choose to be involved, to have some control over the process. Maybe they view it as a form of monitoring, and they may handle a second level claim appeal. So in this case, there's a lot to consider if an employer is considering a self-funded plan, is considering getting involved in the appeal process. They would need to have a prudent process in place, obviously, to review the claim appeals, and they'd have to strictly comply with all these regulatory requirements we just discussed, the timeframes and the notices. They'd have to interpret the claims consistently. Full and fair review is required. Gather information as necessary, medical information and records, consult with experts, and carefully document the process. So employers assuming this role should really consider too whether they should establish a committee to facilitate such a process. And there was a great article, an observations article in Compliance Corner you can check to discuss this issue. But I did want to ask you, Travis, what your thoughts are on this, and in your experience, how many self-insured sponsors, and just among the ones you dealt with, chose to take on this responsibility?
Well, thanks, Carol. I appreciate the question. And one of the phrases that you mentioned, I love, a lot to consider. And sometimes health insurance can be thought of like a sliding scale. When a plan sponsor is looking at a fully insured option, well, they can't delegate all of their responsibility. Many of the day-to-day functions are done by that insurance carrier. When we move into the middle part of a sliding scale, the ASO, where a provider is doing most of those services, but because the plan is self-funded, they have some additional responsibilities to do, there's more to consider. That could be whether to have just the one level of appeal, or if a second level of appeal is part of the plan design, who's going to do it? And the NFP article that you mentioned lists a lot of great things that are reflected here in the slide in terms of whether that second level of appeal, if it is established, should be done by the ASO administrator or the TPA, or if instead the employer wants to take the approach of organizing a committee. In reality, we know that there's a lot going on in the world, and oftentimes plan sponsors or people who are called to serve on certain committees, it's not the only thing that they do, but the regulations require certain standards be met. So if a plan sponsor does go down the route of handling a second level appeal, some things to consider, like were mentioned, are ensuring that the members of the committee have familiarity with health plan operations, have experience interacting with claims. That can be as key to whether a claim is denied for simple things like lack of medical or supporting documents, or if a claim is denied for the very simple reason that just the wrong code was put in, and had the provider build it differently, would have been approved. The other thing too is the realities of ensuring that if a committee is organized, that it's documented correctly, that the right level of note-taking or comfort is listed, and that there's sufficient personnel to be able to hold that committee. Another consideration too is the type of information that they'll receive access to if a committee is organized. Later on in the presentation, we'll talk about how third-party administrators, what I'll call the far end of the sliding scale, can create more opportunities for carve-outs or for more parties to be involved. But it's certainly a lot to consider amongst all the other things that many businesses have to juggle.
Great. Thank you so much for such a thorough response, Travis. Very, very insightful.
Yeah, I really like how you describe that, Travis, as a sliding scale, right? It's really or a dial, right? Are you dialing up the intensity of what's required here for fiduciary governance? How involved do you want to be, particularly for a self-insured? But I think it's really important to note that here, right? If you're fully insured, the dial or the sliding scale is fairly low, as far as some of these things that we're talking about today. And the appeals process is the specific example here. Whereas if you're self-insured, you've just got a lot more skin in the game and you're seeing a lot more information. You have a lot more discretion of what you're able to do, right? Fully insured, you're kind of bound within what a carrier is offering versus self-insured, getting a little bit more creative and making some of those discretionary decisions on claims, on networks, on prescriptions if you have a carve out, stop loss insurance. Like you just have a lot more going on and a lot more decision, and so you're gonna have a bigger responsibility to do some of this in the prudent vein that we're talking about. Um, so with that, we're going to move into kind of the next section of our presentation here, which is talking just about this. And again, this is going to be a little bit more in the realm of a self-insured plan, a little bit more responsibility. But even for fully insured, where you're selecting your carrier, a lot of these concepts are going to apply. But high level, really, again, we want to get back to this idea of what it's all about, and that's how do you, as an employer plan sponsor, prudently select vendors, service providers, anybody who's assisting with the plan. And we're going to focus on carriers and on TPA and ASO providers here. But to start off, there's really no one mandated process, right? There's not a specific outline that you follow and check all the boxes and you hit the deadlines and you're going to be just fine. You really have flexibility to determine your approach, but with that flexibility, you do need to consider benefit plan size, the plans you're offering, the size, the needs of your specific organization, your employees, and the circumstances there. So really, that's some flexibility, but it comes with that sort of heightened responsibility to look at what you have and what you need, and that's going to be very specific to you. Um, but really, you need to be able to show that you're engaging in a prudent decision-making process, and that's kind of what we're talking about here. And so the process should be, more generalities, more collecting and carefully evaluating sufficient information. We're going to talk about some of this, but qualifications of the service providers, reasonableness of their fees, um, and sort of how do you get to that decision that's most suitable, who's the most suitable candidate, and then documenting that process. For some employers, not all, but some may choose to go through an RFP process. That might be the most effective way to do this. That is an effective way to demonstrate your due diligence and can also streamline the information gathering and evaluation process. I think of a little bit like this is probably because I just went through a little bit of home renovation in my house, but think about how you go out for 3 or 4 bids, right? You're looking at all this information. You're looking at each subcontractor for a particular job to make sure that you vet them out before you let them into your home, right? And that's kind of what we're talking about with this process, with the additional step of documenting that so that if somebody else were to come and look at your process, they could see how you got to your decisions and see that you were reasonable in that decision and what were the variables you were looking at. Um, so um, so with that though, in the self-insured context, we kind of have this idea of a TPA versus an ASO provider. And Travis, I'm gonna ask you to kind of go through this slide and talk about this because you have the expertise here.
Well, one thing we know about health insurance is there's a lot of acronyms. So, in the world of moving away from that fully insured space, people may come across the TPA or the ASO options. I'll just note a couple of the bullets here. When we think about TPAs, those tend to be entities that are generally viewed as independent of insurance companies. In some cases, they're owned by a holding company of a large insurer, but they utilize separate branding and may have different offerings. TPAs are utilized in a sense as that far end of the sliding scale because they've got the options to customize services. So if a client is looking to utilize a particular provider network or a different utilization management company, that model of a TPA may be the right choice. Some cons, however, are that there's extra coordination that's required depending on the differences in how the TPA's pipes are set up to different vendors involved in the process. That could be if a carrier, for example, the network is the entity that receives the claims, how they take that information, price it, and then send it to the TPA to adjudicate. And then who does functions like printing the benefit denial notice that we talked about earlier and sending it to a member, and then who handles customer care. For some clients, a TPA approach is right because based off of the needs of their population or the certain services that they're looking for, that level of customization fits in the offerings. In that middle ground approach is the ASO. And generally, these are entities that perform administrative services like a TPA, can do claims adjudication, medical management, customer service, or other things. But they tend to be the insurance company that is offering fully insured coverage, but this is their self-funded model. Because of that, some pros are, they tend to be more streamlined. There's not that hot potato aspect is data is moving from one entity to another back and forth, keeping in mind things like the claims processing timelines that we mentioned earlier. They also, right, have the ability to coordinate internally in a sense because they are providing more services that are under one roof. Some drawbacks, however, could be potentially less flexibility, benefit customization, transparency, in part because many of the operations that are being utilized to support a self-funded plan are the same inner workings that are used in the fully insured model. It's just the funding aspect of ultimately paying for services comes back to the plan sponsor. So self-insured plan sponsors have a lot to consider, and depending on the needs, can evaluate before they ultimately make vendor decisions a variety of options. That could be a mix of getting information on what fully insured ASO or TPA services are available. And then depending on the needs of an employer, that may change over time. My experience from being in the market is there are people who a fully insured model works best for them currently, and then they will move to a TPA model, but that's too much customization, and then move back to the ASO model. Or instances where it's the reverse and a client moves from fully insured to ASO in the middle, tries that for a while, but ultimately, given the number of vendors or preferred partners or different services that are available in the market, bringing in a trusted TPA partner is something that comes into play. This is where the fiduciary responsibility, the asking questions, the things that we had noted can really come into play based off of what a client thinks its current needs are, or where it may be going in the near future.
Yeah, thanks. This is super helpful to just kind of walk through, pros and cons, TPA versus ASO, just understanding the difference, right? Like sometimes those terms get thrown around in our industry as the same thing, and it's helpful to understand some of the differences as well. And yeah, again, going back, like all of this is super dependent on your structure, right? Your funding structure, obviously, fully versus self, what's going to make sense, and how far you need to go in asking some of these questions. Depends on, as you said, what is the carrier allowing? What are they offering? Or the service provider generally, what are they offering? And then, just by size as well. I think there's some different considerations depending on your size. But typically, the type of information that is gathered and evaluated in this process, and again, the actual steps in the process for going through this would depend and vary based on the carrier, the ASO, or the TPA provider. So we're not going to go through the kind of the mechanics of the steps of this type of process, but just generally speaking, the type of information is really coming back to that contractor or subcontractor working in your home type of idea. These are the kind of things that you want to know and learn about and evaluate when it comes to selecting who's going to be working on your plan. So look at the firm itself, right? What's the financial condition? Is there any bad Yelp reviews in a way when we're talking about recent litigation or enforcement actions, performance records, and experience with group health plans? And again, considering the size and complexity of who you are as a company and as a benefit plan, whether subcontractors are going to be involved. Is there somebody else underneath this service provider that's going to be providing services as well? the workforce capabilities, whether they can meet, the needs of the plan. Quality of care is getting a little bit detailed, but the scope of healthcare services, medical providers, what are their ratings and accreditations and experience and qualifications? What does that look like? Provider network access, licensing status. Is there any concern there? Accountability, access, and responsiveness. If there's any statistics that are out there regarding the claim and appeals process that we talked about, quality control. And then if there's any way to learn about the timeframes for responding to questions or problems, if issues that have come up in the past. Technology resources, moving on to the next slide, but continuing the same pieces of information that might typically be gathered in this process. And the technology is important, obviously, with where we are in our world, the ability to address new tech requirements or accommodate a customized plan. What is the compatibility with the different systems between the plan and the carrier, the service provider? Cybersecurity is so huge right now, right? And what are the security standards? And is there any insurance coverage on those? We included a link here for the DOL. They have some tips there relating specifically to, hiring service providers with strong cybersecurity practices. That's really important, a great thing to review to get it straight from the DOL on what they think are some good tips there. Compliance, we love compliance here, obviously, but what is the company that you're hiring doing with compliance? Do they care about applicable laws? Do they speak to it fluently and understand, particularly when it comes to things like the DOL claim regulations and HIPAA privacy, right? We just talked about cybersecurity, but what about HIPAA's privacy and security rules relating very specifically to the information that could be seen here when you're talking about, particularly in the self-insured context? And what are the other things that the requirements or obligations that the carrier or the TPA ASO provider can assist with, like the mental health parity, NQTL comparative analysis, or the RxDC reporting? Some of these newer requirements where really helps to have buy-in and understanding from a service provider so that when you have questions, or even if NFP is assisting and we want to facilitate a discussion and understand what the carrier or TPA can do, just knowing that they can speak to these things a little bit better. What are the other services they can provide? One example here is, just administration of COBRA that would go beyond claim adjudication, creditable coverage determinations and notices, HRA integration, point solution programs or wellness programs. How do they coordinate with all the different parts of the plan? And then, one that particularly for self-insured would be our specialized services. Is there experience or expertise servicing a specific industry? So, and then all comes back to fees, right? How is the compensation from this service provider? And again, when evaluating the compensation, the employer as a plan of fiduciary is not required to select the lowest bidder, right? So lowest cost does not always mean most prudent, is another way to say that. But you do have a responsibility to ensure that the comp is reasonable for the services provided. And so understanding things like estimated fees and expenses, whether those fees are assessed individually or they're part of a bundled arrangement. Reviewing whether there's any additional fees that come along with that, any referral fees or commissions or revenue sharing, that kind of thing, is super helpful. So the best way to do that is, again, this is a newer law that you should be receiving what we call a 408B2 compensation disclosure. 408B2 is just the section of ERISA where that requirement is found, but it's also referred to as a broker compensation disclosure. That would be specific to a broker, but just a planned service provider compensation disclosure should be telling you what the comp is that you are receiving for a particular set of services. So reviewing that carefully, evaluating the compensation, asking questions, benchmarking, comparing with others, again, with similar services, and identifying any potential conflicts of interest, which should be disclosed to you. That process should be documented. We'll talk about documenting here in a second, but um, getting that compensation and making your decision, and again, cheapest doesn't always mean most prudent, but figuring out what works best, and if you are going with a more expensive service provider as compared to others, what are the reasons for that? What are the additional services? Is there a better track record? Is something, whatever helps support that decision, um, documenting that and understanding that. And so speaking of documentation, what does that look like? Again, this will be very specific to your organization. There's no specific form of documentation or template or anything from the Department of Labor or any other regulatory agency, but it's just this idea of maintaining accurate and well-drafted meeting minutes. It doesn't have to be meeting minutes specifically, but if you do have meetings, being able to have those in some form, notes from key decisions. We have in our fiduciary toolkit a template of this, a sample of meeting minutes, and that would be there to help provide a concise summary of the key discussion points, deliberations, outcomes, and that can help write in a neutral tone to help establish kind of the process that went on there. And so if you have meeting minutes, that's a great way to do this. But without meeting minutes, without some type of record of your process and the discussion and the analysis you went through to get a service provider, it's going to be hard to show that you engaged in that required prudent decision-making process. Particularly if you're talking about months and years later, and we've seen this in the litigation, which we'll talk about in a second. If somebody brings a case against you alleging you didn't go through this process, it's very difficult to remember, first of all, what the process was if you don't have good records. It's even harder to prove your case in court if you don't have those documentation, some type of documentation. So we do say retain whatever meetings, documentation, however you're doing this, should generally be kept for about 8 years in a safe place, and where whoever's in charge of the plan, the fiduciaries, they all are aware of where that is, and it can be ready for review or examination when needed. So a lot to consider there. I know that's a lot of information, but again, trying to bring it back high level, just think about that contracting example of these are the people who are going to be, and vendors. When I say people, I mean entities, but the people within those entities that are going to be involved with your plan. They're going to be inside of your house, so to speak, working on the plan and working with your employees and serving the participants of your plan. And so you want to do this due diligence process just to make sure that you feel comfortable with whoever's doing that. And that's really what we're talking about here. And then documenting it so that you can, show that you went through this process. So hopefully that helps with some of the high level type of information that you would want to look at and review and analyze. And then I'm going to flip it over to you, Carol, to talk a little bit more specifically about contracting, right? We've selected who we think is best to work with the plan here as our service provider, as our carrier, as our TPA or ASO provider. What do we need to consider when it comes to contracting with that entity?
Yeah, thanks so much, Chase. Yeah, contracting, I can really look at it as another form of documentation that an employer needs to consider, and it's a very important form. It's a binding legal document, and it should really spell out the obligations of the parties very clearly. There's been a lot of discussions, arrangement prior to this contract, and now we need to make sure it's actually memorialized in writing in that legal document. And of course, we can't provide anything other than general information. So we would always advise an employer to have the agreement reviewed by their legal counsel, who's experienced in employee benefits law, prior to execution and before any performance under that agreement begins. If an RFP or similar selection process was used, that draft agreement should be carefully compared to the information provided by the service provider during the process. And since the services in the agreement will involve interpreting or applying plan language, the agreement should also coordinate with the official plan documentation, the ERISA plan document, SPD. There's often standalone procedures as well that are cross-referenced in those documents. For example, the contract should specify that the parties will follow the claims and appeal language in the ERISA plan documentation, because we know, we've spoken about this in other sessions, fiduciaries have that fiduciary duty to follow the plan language. Where the TPA agreement doesn't assign any responsibility for a particular service and a gap arises, the employer as plan administrator will remain ultimately responsible for performing the service. This is goes back to what I said in the beginning, that plan administrator is responsible for the overall operations and compliance of the plan. So if something isn't spelled out that's being delegated to that particular service provider, then it's going to be the plan administrator's responsibility. Next slide. What are some key provisions to review in the contract? Obviously, we spoke services, performance deadlines that were discussed. Make sure everything's clearly spelled out. Fiduciary status and the standard of care. Deciding claims and appeals is a fiduciary duty. So you want to make sure that the party you're delegating it to is acknowledging they're accepting that fiduciary status in the agreement, and they're going to adhere to ERISA's fiduciary standard of care, prudence, loyalty, following the document. Subcontractors is the CPA for as example are going to use subcontractors, and will they notify the employer and guarantee their performance? I think subcontractors prevent a very tricky situation for fiduciaries, because they're responsible for the subcontractors, for monitoring them, and yet they don't have a direct contract with those subcontractors. So it's important when you're entering agreements, with the carrier, TPA, ASO, that they're going to be responsible for their subcontractors. Compensation, fees, and expenses. Obviously, we want this specified in the agreement, and any situations that may allow for changes in the enrollment population, for example. Next slide. Confidentiality and data security. I know Chase touched on that. That's super important, and there's generally two types we're referring to, right? Each party has their own proprietary and confidential information, and then we also have personally identifiable information, PII, and protected health information, PHI, of employees, which is some extent maybe addressed in the BAA. The guidance the DOL has is really helpful. Sometimes insurance, exchanging cybersecurity insurance, information about your coverage. That's also helpful as well. So I would definitely urge you to look at the DOL guidance, but it's definitely an important aspect of contract negotiations today. Access to claims data. We know we have under the CAA 2021 our gag clause prohibition. So you want to ensure that any gag clauses are removed from the contracts. So if you need to down the line, you can access that claims information, or any negotiated rates. You want that information to fulfill your fiduciary obligations and for cost containment and analysis purposes. Indemnification and limitation of liability. Those are important provisions that you should refer to your legal counsel to review. They're really, designed to indemnification to ensure that your party is protected from losses due to the other party's conduct, and a limitation of liability is really a risk management tool. You're trying to limit your own liability, but both are very important and good to review with your legal counsel. Audit rights, this really leads into the next section. The employer wants to, particularly with a self-insured plan, reserve the right to audit audit the service provider's performance, make sure they're adhering to the contract. And this is a form of monitoring. Whether or not you actually conduct an audit is another thing, but you always want to make sure that right is in the contract and it's spelled out, without too many restrictions. So if you do need to conduct an audit, you can do so. Next slide. Okay, monitoring performance, I'll turn that over to you, Chase, and let you discuss that briefly.
Yeah, thanks, Carol. So monitoring, again, is just this idea of continuing to review, analyze, evaluate how the service provider is doing, right? So we're not done once we made the right selection, and we can show that through our prudent process and our documentation. We need to continue to do that. And so one thing you were talking about with the resulting contract, right, is requiring some type of periodic reporting from the service provider, and also have some term in there that you have the right to audit their performance. So that's important, but just being able to see what's going on an ongoing basis. There should maybe consider establishing some type of formal process to review the performance at regular intervals, and then as part of that process, just having some type of regular standing meeting or whatever it looks like internally to be able to read reports as they're available, asking about policies and practices. We'll talk a little bit about use of AI in the TPA's claims processes, but that might be something to look at regularly. Verifying the actual service fees charged. This is huge, right? We know we've all dealt with sneaky contractors or vendors that put in extra fees that maybe weren't discussed. Or maybe it's just a mistake, right? Being a little bit more innocent about it, but verifying that the actual fees agreed to were the actual fees charged on an ongoing basis. Following up on any participant complaints and addressing those with the vendor to make sure that things are operating correctly, and then holding meetings to discuss plan operations. In addition, consider periodic evaluations for claims determinations, and again, accuracy, timeliness, and substantiation, and periodic audit of the claims administrator themselves. So audit types can vary widely, but some things to consider: due diligence audits involving a random or targeted sampling of claims over a recent period is one way to do that. Appeal audits that are of a random selection for internal appeal and external review documents. Implementation audits before changing a service provider or plan design. And then customer service audits to see how things are going there. So again, all of this kind of comes back to your size, your particular plan type, and the number of plans you have involved, funding type, again, that's self-insured versus fully insured, and other circumstances that are specific to your arrangement. But just that idea of continuing this process, it's meeting regularly and documenting, how is it going? Where are the pain points? What's not working? Addressing those with the service provider, and then continuing to monitor throughout. So that's the monitoring part of this, and is all the same ideas with selecting, just continuing those ideas, and then the overarching idea of documentation. How are you going to be able to show this later? So with that, we're going to move a little bit away from this idea of selecting and monitoring. Not completely, though, because it's involved in the recent litigation, but we did want to just give an update on what's happening in the courts. And Carol's going to walk us through this with a little bit of insight from Travis as well.
Thanks so much, Chase. Yeah, just a few of the first two cases just relate to the claims review process. And the first was the one I mentioned earlier, and this involved parents, and they finally went to court. Their daughter, a teenage daughter, had been in received residential treatment benefits for mental health and substance use disorder benefits, and the parents were denied originally part of their claims, so they appealed it. And the correspondence that came from the plan was really grossly deficient. It didn't meet any of the DOL regulatory requirements for denial notices. And, in this case, the court, really got exasperated. And the case was remanded back to the insurer to reconsider the claims. But this is not an isolated case, and we have deficient denial letters commonly cited by courts. And it's a problem really, and you may feel as a consumer that you receive a notice and you don't understand, and we work in the industry, what they're asking for or why a claim was denied. So, we may see more of a focus on this. I would mention there was an initiative of the ERISA Advisory Council. It's a private group that was presented to the DOL. We don't know the status of that with the new administration, to make some changes and in some ways to be more participant friendly, given the low rate of appeals. So that's one trend. And we'll have to see what happens under the new administration. The next one I think is particularly interesting because it involves AI, and this was a case that class participants brought against Cigna regarding their use of AI in algorithm in deciding claims. And this court allowed us in an early stage, allowed the case to go forward, denied the motion to dismiss. And the argument here was that, the AI was being used where it shouldn't be to review a claim of medical necessity, and it should have been done by a medical director. So I think this is really interesting because I think most of us accept that for simple claims, maybe we have dental, vision, low value claims, that it's, the automation, it's a cost savings. It wouldn't be cost efficient not to use some AI. But obviously, in this case, at least the allegation was that it was not consistent with regulatory requirements, the use of AI. Travis, do you have any commentary on that from what you've seen from your experience in AI and where things are going?
Hey, so, I'll note that whether it's a fully insured carrier, an ASO administrator, a TPA, everyone's looking for opportunities to create efficiency in addition to cost savings. So automation, AI, offshoring, all things that come into play for plan sponsors. Part of that monitoring is asking those questions where needed to feel a comfortable level with what the operations are without getting too far into the nitty gritty, where as a plan sponsor, then you're taking on additional things where maybe those hired experts are performing their role. Litigation is a good example of a canary in the coal mine for potential issues that could occur in addition to things like the complaints that come into customer service or the type of topics that are coming up in appeals. And depending on whether a client is fully insured or self-funded, limits the amount of access to PHI they have available. But certainly something where in the larger industry, we can see that there are some challenges based off of this duty of a fiduciary and whether or not they've breached their responsibilities or their hired vendors have done so.
Okay, thank you, Travis. Yeah, it's interesting. It's going to be interesting to monitor this use of AI and the cases. So yes. Next slide, Chase. Thanks. And just briefly, and we've talked a lot about the fiduciary breach litigation. That was really one of the factors I think bringing about this focus on fiduciary governance on group health plans. And these cases are still out there. And of course, in these cases, they're class action lawsuits, and the participants are claiming that the fiduciaries failed to prudently select their service provider, particular focus on PBMs, negotiate competitive pricing, and monitor the service provider's compensation. And they generally are arguing that they were hurt by these and caused to overpay for premiums and out-of-pocket costs. So far, these cases haven't been successful, haven't been able to move forward, but yet they present legal risks and potential liabilities for group health plan sponsors. Best way to protect yourself is to engage in that prudent process, and document it. A lot of you are taking steps, I'm sure, when you select service providers, but document the process and also be sure you have a way to monitor that service provider's performance. Next slide. And thanks. Yeah, these are the cases. They're really all still out there. You know, the claims were dismissed, and now there's amended complaints that may be filed, or we're waiting for rulings on them. And that's kind of, we expect the pattern here, that we're going to see more lawsuits or, you know, attempts to amend the original complaints that were dismissed. So again, we'll just have to monitor and we'll certainly report on any important developments in Compliance Corner.
Yeah, lots going on in the litigation front. Always good to get a little bit of an update and just kind of gauge the temperature there. So good to know what's going on. Thanks, Carol. Thanks, Travis. So we're approaching the end of our hour, and we know it's a long hour when we're talking this dense of material. But some final takeaways for employers. Really, again, kind of come back to our agenda items, right? You can delegate, as a plan administrator, you can delegate those fiduciary obligations in accordance with the plan document. And really, here's the considerations when selecting a service provider: is defining the role really that you want to outsource, engaging in that prudent process to select the service provider. Compensation is a big deal, so evaluating that for reasonableness. Again, cheapest is not always most prudent. But having the reasons for going with whatever you've chosen, and obviously comp is a big part of that. You may need legal counsel in reviewing the contract for the service provider, right? We went over some basics here, some things to look out for, but we are not your attorney. We are not able to review those contracts on your behalf, even if you're an NFP client. So may need legal counsel there. Monitoring, again, ongoing. And then documentation is a big deal. Figuring out what works best for you for documenting and keeping records on how you got to these decisions to go with a particular service provider. So good news, we have a really nice publication on this. We've talked about this on every call, and we continue to push this. And if you don't have a copy, your NFP contact can get that for you. But it is called ERISA Fiduciary Governance, a guide for employers. It does also, include a lot of information about each of the steps that we believe and think should be part of an ERISA fiduciary governance program. And we are only covered a couple of those steps here with selecting and monitoring service providers. So there's much more, including some of the meeting minutes we talked about, employee benefit committees. If you need a committee, how do you do that? And then just a general description also, if you're still at 101 level here and trying to understand what is the fiduciary duty that I have, we have a lot of information on that as well. We also include in this an overview and checklist as one of the appendices to this document and this publication, and that includes kind of a high-level action item. What does it look like if I could just see this on 1 or 2 pages? The steps I should be taking, and a checklist with a place for comments and status. That we've found has been very helpful for employers. And then some sample documents with our board resolution and charter if you need to establish a benefits committee or board, a summary of committee duties and responsibilities, appointment letters to be able to tell or appoint those individuals that you want on a committee and what that looks like and what it means, and then meeting minutes. Somebody asked in the chat, how do I get those meeting minute samples? And so that's in there as well. So lots to cover here. And lots that we have covered. We'll send around the slides and the recording to anybody who registered for this call, and we'll also include the the publication with that. And then looking ahead just a little bit, we do have our upcoming fiduciary focus webinar, the 4th out of our 4 in our series in September. And you can go back and listen to parts 1 and 2 as well through these links that are available at nfp.com. We'll continue to cover any updates through our newsletter, Compliance Corner. That's also available at nfp.com on our Insights tab. With that, I know we're at the hour. We really appreciate the time. Travis, Carol, it's always a pleasure to present with you. Wonderful insight. Thank you for the time and insight there. And with that, because we're past the hour, I think we've been answering questions as we go in the chat. But if you do have questions, please reach out to your NFP contact and we'll be happy to talk more with you directly. With that, I'm going to flip it back to you, Amber, to sort of close us out here.
All right, great. Thank you, Chase, Carol, and Travis for sharing your valuable time and expertise with us today. To reiterate, today's presentation was recorded. We'll be sharing the recording in the follow-up email and on the NFP website. If there are any portions of this call that you missed, by Monday, you'll receive an email with a link to the full recording. The PowerPoint slides used today during the presentation will be shared in the same email. At the end of this call, a survey will populate in a new window. Please take a brief moment to complete the survey as it lets us know what topics are important to our listeners and helps make our education program as current and relevant as possible. That concludes our webinar for today. Thank you everyone for joining us and have a great day.